matters. That's you up and running. I'll just go and hide myself.
Okay, thank you. Well, good morning, ladies and gentlemen. Welcome to the pre-examination meeting in relation to the Scottish Borders Council 2 High Street 12 Marketplace Jedburgh Compulsory Purchase Order 2020. My name is Paul Kent. I'm a reporter with DPA, the Planning and Environmental Appeals Division of Scottish Government, and I have been appointed on behalf of Scottish ministers to report to ministers in relation to the justification for this compulsory purchase order and the outstanding objection to it. The public local inquiry for this has been fixed for the 5th of May, and there is one outstanding statutory objector, Anthony Sivrite, who's represented by Ken Goddard, who's on the call this morning, and we have Sarah Thompson of Scottish Borders Council acting on behalf of the promoting authority. I circulated on 31st May a suggested agenda for the meeting this morning, and I'll ask in a moment if anybody has any further suggestions or modifications to that agenda for how we're dealing with matters this morning. The purpose of this procedural meeting, notwithstanding the closeness of the public inquiry date, is to seek to address one or two outstanding procedural matters that need to be touched on in order to ensure the effective operation of the public inquiry on the 5th of May. The purpose of this meeting is not to hear evidence or representations or matters that are properly should be left for the public inquiry itself, which, like this, will be webcast and available for members of the public to watch, but to try to ensure that we can secure as an effective and efficient utilisation of our time on the 5th of May. The order and the holding of the public inquiry has been advertised by DPA, by my colleagues in DPA, through an advert on the 8th of April in the Southern Reporter, indicating the intention to hold the inquiry virtually on the 5th of May, setting out that the inquiry will address the Council's justification for the order and the outstanding objection or objections on behalf of Mr Sivrite. The intention is to have the public inquiry lasting one day, but we'll discuss this morning whether that remains the view of parties as to how that will proceed. As I say, the agenda was circulated previously. I think probably one of the first issues probably I should like to address is I know that Mr Goddard is phoning in today rather than appearing as Ms Thompson is on video conference along with myself, and it maybe it's a sensible place to start to just address some of the issues that might arise in connection with that. But before I do so, I wonder whether anybody, either Ms Thompson or Mr Goddard, want to say anything by way of introduction or introductory comment in relation to this meeting, and or suggest other items that are relevant in relation to the agenda. And I'll go to Ms Thompson first.
Just for a start, it is Mrs Thompson if we're going to...
Oh, you're all right,
yeah,
Mrs Thompson, okay. Cool.
That's falling apart. Just about using our formal titles.
Okay.
I'm content to stick with, if you allow me a moment to fix my headset.
Okay.
I am content to sit with the terms of the agenda that you've sent out, sir, and proceed on the basis that's laid out. I appreciate there are some technical difficulties facing Mr Goddard, and I'm sure we can discuss them as matters progress. From the Council's perspective, any witnesses are able to access any web streaming set up for the inquiry. I've spoken to the two principal witnesses, and they both have sufficient web access that would allow them to access WebEx for that.
Okay, thank you, Mr Goddard.
Yes, I'm relatively happy with that. In fact, witnesses are probably more accessible to it than I am here. So
yeah. We'll come to this in a bit more detail later on, but I think, is it your intention that Mr. Sivright is your only witness that you're intended to call?
Well, I haven't seen in detail of who the council wished to call, so I would want to cross-examine.
Sure, no, absolutely, yeah.
So therefore, I'm not sure whether I would include those cross-examinations on my witness list or will be on Ms. Thompson's witness list.
Yeah. I think I presume on the basis that you would have an opportunity to cross-examine the council's witnesses and without giving particular notice of anybody else. The question really is in terms of your own client's case. I'm assuming he will want to be giving evidence, whether it just is on reliance on his precognition, and that will be available to be cross-examined by the council in the inquiry. My question, I guess, is to whether you're intending to have anybody other than Mr. Sivright giving evidence in support of his case, as opposed to cross-examining the Borders Council's witnesses.
Yes, I have one other witness that I wish to call.
Okay. Well, that's fine. We'll come in detail to that in a moment. I suppose for this stage, I guess, I suppose the question again is to ask you to try to be as confident as you can be that both Mr. Sivright and that other witness has sufficient IT access that will allow proper participation at the inquiry itself. And I'm conscious from your own context, Mr. Goddard. We can hear you very clearly, but obviously if we're not seeing you and if you're not seeing us, that's creating a bit of a challenge in relation to how you represent your client at the public inquiry itself. But I don't know whether I
might relocate to one of the witnesses so we can share the same facilities.
Okay. Okay, but that's fine. I was going to say, I mean, either if you can relocate to where one of your witnesses is. I know Mr. Sivright has an address at least down south, so he may not go there, but he may have an address here. You can go more locally. We're finding restrictions are being lifted to an extent, but I don't think you can go to England yet. The other option might be, and I don't know if this is feasible, to try to get access through maybe Angus Council, may be able to offer facilities, can allow in the circumstances to allow you to participate through use of stuff there. But obviously, I want to make it as fair and as reasonable as I can for you to feel that you can represent your client's interest as well as you can.
Thank you.
Notwithstanding the difficulties.
Yeah. Well, I can certainly pursue that, but it gives me two options to pursue. I will take it up with Angus Council for facilities and/or go to the witness.
Okay.
So
well, to a certain extent, we'll see how this morning goes.
Excellent.
Sorry, okay. And is there anything else on the agenda, or are you content with the agenda?
No, I'm content with the agenda. I mean, I think it's understanding the scope of the inquiry and the limitations of the order. Yeah.
No, absolutely. Yeah, and that's very helpful. Thanks to both of you for that. The first item on the agenda was the confirmation of the grounds of objection, and I'll ask Mr. Goddard to speak to that in a minute. I should perhaps say from my perspective why it's quite important for me in terms of my role in reporting to ministers on the justification for the order and on the objections outstanding, and again re-emphasising that it's not for today to hear the merits of any objection. That'll be for the PLI itself, but it is quite important to be clear so that this can assist the process on the 5th of May, both for myself, for Scottish Borders Council, and for the witnesses giving evidence. It's important that there are no surprises, that we can give fair notice of what the grounds of objection are. You've made a point, Mr. Goddard, that the Council obviously know the detail of this order. It's been around for a number of years now, so it's clear that the background is well known. But in one sense, from my perspective, that's not quite the point as far as why we need to be clear about the objection and the grounds of objection. But on the 5th of May, it's really just to ensure that, as I say, there's a kind of fairness to all witnesses, including your own, but also a question of making sure that we get the right witnesses attending. You'll have seen that Mrs Thompson has given an indication as to, at this stage, who she thinks are appropriate council witnesses, and the last thing that I would want to have is a situation where we get to the 5th of May and you have legitimate questions to ask, and the council might know the answer to that question, but they've not brought the right witnesses along, effectively.
Certainly,
So
yeah.
it's ensuring that it's sufficiently clear for them to prepare a witness list and the precognitions, so that the issues can be tested on that in such a way that can make the time most efficient and most effective. And really, I mean, I've read the statement of case on behalf of the council, and I've refreshed my memory. Initially, going back to November, Mr. Goddard, in your letter, emphasising that you were maintaining your objection, but also Mr. Sivright's various letters in the form effectively of precognition that have been sent, including over the past few days. So it'd be useful maybe if you could maybe sort of set out just in very brief terms, you don't have to elaborate in detail what's relevant for the inquiry, but just to be, if you could just set out what the grounds of objection are going to be to enable fair notice to be given to the council as to what they need to answer when we get to the inquiry.
Certainly. Well, I think principally, whilst we're not going to discuss finances at this particular junction, the objector's claim is basically again to it is not his. He doesn't have the full authority to grant a CPO.
Yeah.
He's also looking at the council in terms of the council provided a witness statement from Harry Turnbull Limited regarding as a structural engineer. Meantime, Mr. Severight and the other residents of the building had an independent structural report submitted, which completely contradicts the council's witness statement. Therefore, I think the two reports need to be considered and probably provided by expert witnesses. That's first part. Second part, we move to procedurally. We're almost in a situation where the objector feels that he's not been given any choice other than to submit to a compulsory purchase order. It's been, in his words, he was intimidated by costs, and the costs seem to have been rising with no correspondence to support how those costs have appeared and how they're apportioned. So again, we'll be looking at costs. We're looking at the way the council have moved from one stage to another, and we've ended up here with very little sort of remedial negotiations or conversations between time. And now we're faced with almost an academic situation where it's a compulsory purchase order application for a building that virtually doesn't exist. I don't really want me to expand any more on that, or
I'll maybe ask Mrs. Thompson to comment on aspects of that, and then we can take that from there.
Thank you.
Thank you. So obviously, Mr. Sivright has made general comments throughout this without necessarily identifying the specifics of his objection. So in relation to the independent structural report, it was my understanding that was instructed, obviously this is not a place for fact, but just to give a bit of a background, that this was instructed by one neighbour. And yes, it perhaps is contrary to the council's view. We have taken one view and they have taken the other. I understand the neighbour in question has agreed to voluntarily transfer their property subsequent to discussions. Procedurally, the objector has not been given any choice but to submit. This has been going on for around 6 years prior to us reaching this point. Now, obviously, the CPO decision has not been going on for 6 years, but the issue in relation to this building has been going on for around 6 years. I would suggest that there has been opportunities for Mr. Sivrite to become involved or make decisions or take actions on his own part. And it seems somewhat unfair to make such a statement. But again, we can address generally the procedure, but it's unclear what specific point Mr. Goddard is wanting to get at, but I certainly can, in the course of the inquiry, have my witnesses address the procedure that has taken place and what contact there has been with all of the residents of the owners of the property. In relation to discussions, I'm not sure that's necessarily a point for the inquiry. A settlement was offered. It might not have been a cash settlement, but it was a financial settlement, has been offered to all owners of the property. The fact that Mr. Sivrite did not accept this does not mean that that has not been offered, and it has been offered on a number of occasions. The council can only go, we're in a position to only go made a decision to have a certain limit on any discussions, and if that was not to be accepted, then the next step was to go to the PLI. But I'm not sure that side of things is necessarily relevant for the inquiry. The fact that we have not come to a settlement, that in itself is obvious because we are now at the point of an inquiry.
Yeah.
If there's anything else you'd like me to address, I certainly can do
Sure.
so. But just on the points that Mr. Goddard has raised at this stage, that would be my initial views on those.
Sure. Yeah, I mean, it's useful obviously to get an indication as to sorts of things that your witnesses might be asked, and can expand on the evidence based on the responses to those. And I think that's, as I say, the kind of main purpose of this. And one of my questions, I guess, to Mr. Goddard, I mean, I see there's things in there in relation to kind of financial viability and the like, as to whether Mr. Sivrite is objecting in principle to the idea that there should be a compulsory purchase order. So I mean, does he accept that the building is dangerous? Does he accept that demolition is inevitable here, or whether are his concerns really to do with how we've kind of got to this situation where it's not financially viable to look for an alternative? I mean, is that the sort of territory that you'd wish to explore, Mr. Goddard?
No, if I could just come back on Ms. Thompson's
Sure, of course.
couple of comments. In terms of the financial settlement that was offered, or the financial arrangement that was offered, there's been no quantification in terms of if he asks for extra compensation, which I know comes down to a land tribunal issue.
Yeah.
So I'm not looking to address that here. But on the basis of if the council is saying he's indebted to them by the sum of X, then they need to quantify how that figure has been arrived at, and that's never been done. Similarly, in terms of this compulsory purchase order hearing is relating to one apartment in the building. Well, the building was jointly owned. I mean, yes, this is predominantly about Mr. Sivrite's flat 12B, but above that, I'm assuming is 12A, and below it is 12C, or vice versa. The issues then, in terms of where the building was dangerous, was an external facade. Therefore, that's not entirely in Mr. Sivrite's ownership. That becomes an item in common, which would have been, in my opinion, subject to a general buildings insurance claim, which should have either been made by the overall sort of head leasee or a joint insurance claim by all of the parties. Now, he is therefore responsible for one fifth of the building.
Yeah.
And I think that hasn't been addressed.
Yeah. I think the council's statement of case sets out proportions of costs that are assigned and allocated to different parties. But I was assuming, Mr. Goddard, that your concern effectively was that these aren't a true indication of what the costs either are or ought to have been if this had been gone about a different way.
That's correct.
Yeah. I don't know if Mrs. Thompson, you want to ask any questions about that again, just really for clarification as to the sorts of things that we'll be looking to address on the 5th of May.
Does Mr. Sivrite intend to speak to that himself or call witnesses to support his view on that? Because obviously the council can present their case, as to the justification and how we have reached the decision to make the CPO and then following the CPO procedure correctly. And we are in a position to do that. I'm not sure we can necessarily answer questions on somebody else's report aside from to say that we do not agree with its terms and we agree with the terms of our report. I'm not sure we can necessarily make comment on different figures because they have not been created by our witnesses or our experts. I'm not sure it is necessarily within the gift of the council to ensure parties work together to make an insurance claim, because if the parties had done that, there perhaps would have been no reason for the council to become involved. The council do not become involved in these sorts of cases unless there is a purpose and necessity to do so. So whilst I am more than content that the council will be able to justify their position, I'm still struggling a bit to see how we might respond to some of these general points without maybe a witness on Mr. Seabright's part to support that. And I'm not trying to be difficult, it's just at points it's been quite difficult to tease out what extra value we might be able to add to this inquiry beyond our own case and our own justification. I have witnesses who will come in and speak and who are experts in their field. That doesn't mean they are able to answer questions on things they have no knowledge of. And I think that is a slight concern for some of our witnesses, is that they are going to be asked questions of things they have no knowledge of. Now, of course, I have told them that if you don't know, you don't know. But I don't want that to be a waste of time for the inquiry. And I think that's something we might want to clarify in advance of the inquiry.
Well, we'll touch on that in a few moments when we come to the question about the witness and documentation that the objector will be putting forward. And one of the questions and issues that comes into my mind, and again, I'm not looking, Mr. Goddard, for an answer to this question just now, but I'm also conscious that specifically here in relation to the past actings of the council or in relation to the defective building and then dangerous building aspect of all of this, that's something that in itself is not necessarily linked with a compulsory purchase order, because the council can take dangerous building action without taking necessarily compulsory purchase order action. So I guess one of the questions in my mind is mindful of the remit that I have for reporting to ministers on the taking of the order, whether these issues are relevant to the justification for the order, or are relevant to kind of, if you like, different procedures and different processes under the Building Scotland Act, which has been referred to in the council's statement. So I guess one of the questions I think in my mind, and I guess I'm not really looking for an answer right now, but just thinking about the clarification of the objections is the matter of what you would be looking to me to report to ministers on as a kind of an outcome from all of this. So your client clearly has a number of concerns about what's happened in the past. I have to address the question of the justification for the compulsory purchase order now, as to whether it's appropriate to proceed. So thinking about questions about what ministerial alternatives are there. Even if you're right about the kind of it could have been less money, it could have been other sums. Where that's going to take ministers when they're asking the question of do they confirm the order or not? Right. If that makes sense.
Yes, it does. I mean, for example, one of the issues will be the tendering process that the council used and obtaining sort of best use of public funding.
Yeah.
In terms of, I'm not quite sure how you issue a dangerous buildings notice and then issue an improvement notice. I mean, once it's dangerous, it's dangerous. The only way you can improve a dangerous building is to make it less dangerous.
Yeah. Yes.
And I think some of these issues will invariably look, when you look at the two buildings reports, the council's structural engineers report and the owner's engineers report, they require expert witnesses to interpret, because it will be sort of one witness, not necessarily cross-examining another one,
No, but competing
providing
evidence.
answers. Yeah.
Yeah.
I mean, things like another thing in terms of costings. I mean, it was agreed an inspection scaffold will be erected. Well, an erection, if you were a contractor and you're quoting for an inspection scaffold, it's price A. If you're then looking for a support scaffold, it's price B. To then convert an inspection scaffold into a support scaffold is a completely different set of finances.
Yeah.
And the fact that it's been there for a number of years also has created an ongoing expense.
Well, indeed, yes. So I understand. So, Mr. Goddard, is it partly your client's position that, linked with the issues you've just discussed, that actually reinstatement without proceeding by CPO is a viable option?
I think
that is not his view. Yeah.
Well, the objector actually would prefer to have defeated the CPO and have his own apartment back. The fact that you're then trying to reinstate a mid-floor apartment with nothing underneath it, nothing above it, defeats the whole object.
Yeah.
So he almost has no choice, because he can't reinstate parts of the building that would have been in joint ownership or used for the common good.
Okay.
And I think some of the repairs that have been done, or some of the remedial works that were necessary, may not have been necessary.
Yeah. Okay. Now we'll go on in a second to how that plays out in terms of the actual evidence itself, but subject to that, is there anything, Mr. Thompson, you want to say further on the indications of those grounds of objection?
No, I will say though, we haven't really been given, I mean, we will deal with it at the inquiry. We haven't really been given notice in relation to requiring evidence in relation to the tendering process. That wasn't included in Mr. Sivright's reply to our statement of case in any obvious way that would have been a point of objection. It was in an email of the 6th of April from Mr. Goddard to the DPAA, but unfortunately that wasn't copied to us. I happened to come across it. It was only published on the DPA website on a Wednesday. I don't ordinarily work a Wednesday and Thursday, so I only came across that last night. And there was terms in there, but it wasn't really significant notice that is something. Now, I do have our quantity surveyor lined up if required as a witness, but I hadn't ordinarily considered we might need him depending on the outcome of today. Now, obviously we're going to, but again, that's the situation. We haven't had huge notice that's going to, I'm just raising that as a point because we weren't given really any notice that is something we would have needed to cover in detail. It has been, as I've said, quite difficult to pick out the particular areas of detail we might have needed, and we wouldn't necessarily have gone into detail on the tendering, aside from the fact that we went through a tendering process, which one witness, our sort of main enforcement officer, can speak to the fact that we entered a tendering process. I now will need to speak to our QS and get significantly more detail in relation to the tendering. That is the situation we are in. I'm happy to support the PLI in that way. I'm simply raising that as a point that, again, I'm concerned that this lack of specification may result in things coming up at the inquiry that we haven't had notice of, and using that as an example of something we really haven't had notice of, and I just simply came across in an email that wasn't, I'm sure just by accident, hasn't been made available to us.
Sure. Well, apologies on behalf of EPA for that, but I mean, clearly we need to try to ensure that we're proper notice is given on all these issues. I was going to suggest moving on to items 2 and 3, and I'm going to actually reverse the order of them, if I may, in light of that, the discussion first of all, because I think although I'll be very much looking for the acquiring authority to be going first effectively in their evidence at the public inquiry, that would be the norm. It isn't the universal rule, but it's the norm. And I think still seems to be sensible to be doing that. But I wonder if we can move actually to what was item 3 on the agenda, Mr. Goddard, and that's the question of the areas of evidence for the objector. Now, I think we've made some useful progress this morning in giving a bit of clarification as to what is intended to be addressed. The information that we have, I think, is we have the objector intending to be led by you as a witness, and you mentioned other experts. giving evidence, and also presumably lodging documents. And I saw in the most recent note on your client's behalf, there was a reference to the supporting documents section. So there's two things there. One of which is we need to have an indication, and the normal rules are that precognitions are meant to be lodged 14 days before the inquiry, which is actually quite soon. I think it's next Wednesday, in fact. So if it's the position that there's going to be other witnesses for the objector other than Mr. Syverite himself, and if there's going to be documents that are being produced, then that's obviously a matter of quite significant urgency, that we know who those other witnesses are, and that precognitions are lodged by an agreed date, and indeed that all documents that parties wish to rely on are lodged sufficiently far in advance of the inquiry, for the sorts of things that Mrs. Thompson has spoken about can be addressed. So I don't know if you can elaborate on that, as I say, Mr. Goddard, who your additional witness or witnesses are going to be, and what your thoughts are for their precognitions to give notice to me, as much as anybody else, as much as the council, as to the sort of substance of the issues to be explored on the 5th of May.
Sure. Well, you have to appreciate that I've only come into this matter to deal with the or to assist Mr. Syverite on the CPO.
Okay, yep,
and that left very little room for dialogue, other than a CPO application was made, and therefore we had to have an objection. Had we gone through a different course of dialogue, we might be in a different situation. One of the attendees or witnesses that I wish to call is the principal of Colin Addison's The Structural Engineers Report. The other one is, sorry, Ben, I'm going to go through my papers on this.
Right.
Having discussed with one of the issues the council has raised is the building is of no value. Now, I'd like to explore that in a lot more detail in terms of the valuation that we have is a different valuation from the one that's been provided by the local authority. So I'd be looking to bring in a valuer as an expert, as a witness for that as well.
Yeah, and what would that witness be speaking to, given that valuation matters are not for me? It would have to be in relation to the objections that you've spoken about already.
It's the financial viability of looking at the council have indicated they have no plans for the building.
No, sorry, say that point again, Mr. Gosh. The council have indicated they've no.
They indicated that they had no sort of pre-requirement to take over the building. Yeah. They also indicated that they had no intentions or no specific use for the building. We've spent sort of looking through the documentation. There's been 6 years or 5.5 years of we need to reinstate the building. Mm. And then the last chapter is let's demolish the building.
Yeah.
So I think we need to go through the whole history of the saga, rather than just.
Sure. I mean, a bit of that is in the council statement of case already, and I'm conscious that in terms of because part of the building I think is a Grade C listed building, and the demolition consent, as I recall, was granted in 2019 after presumably consultation with Historic Environment Scotland, if it was called that in those days, and they didn't object. But there's clearly a kind of there's a bit of background there that may not be factually agreed, and again, I'm very happy to hear evidence on some of that background. But again, so long as it links with issues that are relevant to the question before ministers, and that'll be as to what the justification, whether the justification is made for public acquisition of a private interest, and how that plays in to the arguments of Mr. Siverite. So there may be a role to an extent, but again, I would suspect fairly focused on those two issues. I don't know, Mrs. Thompson, you want to say something? I'll come back to Mr. Goddard in a second.
In relation to valuation, I'm not sure how relevant that is to the points that I appreciate. It adds a flavour to the full picture, but I hadn't ordinarily intended on calling the district valuer because I didn't feel as though her evidence was necessary to overall support the justification to the point that we have reached. Now, that is who we instructed the district valuer to act on our behalf as far as valuations and negotiating with parties. And valuations, again, they can differ because they can be taken from different standpoints and with different factors in mind. So the information we have provided the district valuer for her to work from to create the valuation that we are then using may be different from the valuation Mr. Goddard and Mr. Siverite have received because they have provided different information. But on the basis of the objections, as far as I can work out, I'm not sure how relevant that is. But if that is something that my witnesses may be asked, the only witness really that would be in a position to make any comment may be the district valuer, who I had not intended to ask because I had not intended to call as a witness because it was not clear that that was a key point of contention from the perspective of the granting of this CPO.
Yeah. Yeah. And Mr. Goddard, is the evidence from the valuer, is that valuation evidence, or is that evidence of somebody who happens to have been involved, who knows about the history, if you like? So we avoid getting into things that are not within the remit of the inquiry.
No,
because if it's just about narrative history and not about valuation matters, then there won't be a need for the district valuer to attend, and presumably the council's quantity surveyor evidence can counter that.
Where we come to here, so is the fact that when the building was in its early dangerous notice state, if we can sort of categorise it under that, the Jedburgh CARS grant money that was being made available, and that whole issue needs to be explored in terms of that funding has been available or been alleged to have been available for the reinstatement of the building. And that will have an effect on terms of the valuation or how they saw X percentage of funds being allocated to repair the building. And now that funding is still in place, and it's not been explored rather than go down the route of demolition.
Yeah, I mean, I'll come to Mrs. Thompson and say I had noted the suggesting of funding, and the funding might still be available until the middle of next year. There may be factual disagreements over availability and the like in that respect, but I don't know if there's anything, Mrs. Thompson, you want to say about that question of funding, again, in the context of relevance to the issue before ministers.
Again, one of our principal witnesses is our senior enforcement officer. He will be able to give a real flavour of the whole process as he has been involved throughout. I did raise the issue of the CARS funding with him because I wasn't working for the council back when the CPO when this building was first in issue. So I have knowledge from a CPO perspective, not necessarily when it was a dangerous building. As is standard, it wouldn't normally come to us unless there was come to the legal team unless there was an enforcement issue. It is my understanding that there were some meetings between owners and parties at the council to discuss the CARS scheme, and there was a CARS scheme available. However, it is for the owners to facilitate that themselves. It wouldn't have been for the council to become involved in that. As far as I understand, now I appreciate I am again giving a bit of evidence, but more just a factual flavour. I'm trying our best not to. My understanding of these sorts of schemes is for all owners to come together to make this happen, and it's wouldn't be appropriate necessarily for the council to push for that. They can signpost certain options that may be available, and I understand that this was signposted to the owners, and I understand that I'm sure at the point of the inquiry, if this was relevant, Mr. Geldner, our enforcement officer, would be able to speak in more detail about it.
Well,
but that the council, I believe, did signpost cars, but it is a matter for the owners. It's not a matter for the council to make it happen.
yeah, okay. I mean, I guess that's useful to know that a council witness can answer questions.
Yes, there is,
as far
which
as,
I did confirm that prior to today.
That's the purpose of today, because it was something I noted as well. I suppose for me, Mr. Goddard, the question in relation to funding is probably less about what steps were taken in the past, but if the argument is that the ministers should not proceed with the confirmation of this order because of potential funding to look to a kind of viable alternative, it's how realistic that is, how that plays into the overall question. That if that's an alternative that ought to be pursued, then I can see that plays into a question of the justification for the scheme, but it's kind of, I suspect it's forward-looking rather than looking at what's happened in the past. To a certain extent, the rights and wrongs of the past are important and are clearly important to your client, but the question before ministers is, do they proceed to confirm this order, or is there something going forward that can be done differently? Mr. Goddard?
Well, I understand what Ms Thompson has said, but I would want to challenge that anyway, and particularly with Colin Gilmore from the CARS project, who's indicated that he would be willing to provide a witness statement, or appear as a witness. So there are witnesses in terms of the funding that's been available and the way it's been described that I would want to challenge the council on.
Yeah.
In terms of the way forward, well, yeah, the building is in the situation where it's in, but I'm still not in favour of demolition. So I think that it's worth pursuing, but the order shouldn't be confirmed.
Sure. So where does that leave then in terms of the witnesses you're intending to call then? As the standard rules, although this applies to all parties, suggest that recognition is required to be shared 14 days ahead of the inquiry, which is next Wednesday. I mean, it may well be that you have other witnesses you want to call, and you're entitled to call those witnesses, Mr. Goddard, as I say, supporting the objections as we're trying to clarify them today. But you're going to need to have those in place and lodge those documents by next Wednesday or such other date as we agree. And obviously, we can agree a date closer to the inquiry, but that leaves less time for all parties to prepare for the inquiry. And I'm hoping that Mrs. Thompson has enough of a general indication to know who she wants to call as witnesses and what those precognitions will say. But I guess my question, primarily to Mr. Goddard, but to both of you, is where does that leave us in terms of witnesses you want to call? Because you're going to both have to make quite quick decisions and get those witnesses to be lodging precognitions, as I say, by next Wednesday or shortly after that, in order to give fair notice to the other side as to the topics that they'll be subject to cross-examination on.
Well, I would like to refer to 5 witnesses.
Okay.
Which I can name. There's Colin Gilmore from CARS, Mr. Rogers from part of the Addison survey construction, Barry Allison, Mr. Severite's valuer, and Mr. Severite. Okay.
So I've got 4 there. Have I missed one? Mr. Gilmore, Mr. Rogers, Mr. Allison, Mr. Severite.
Mr. Severite's valuer.
Oh, and that's different from Mr. Allison.
Yes.
All right. Okay.
Can I ask what Mr. Allison would be speaking to?
I think there's reference to a meeting that was back in. I haven't got a date in front of me. There was a meeting that was held between the owners and the authority.
And when was this?
Sorry, bear with me 1 second.
Don't worry.
I think it was about sometime in June 2018.
Okay. And it'll presumably be clear from Mr. Allison's recognition what point arises from that that's relevant to the objections that would help me write my report, but would also help the council's witnesses get an understanding as to what they're likely to be asked about.
It's more a question of the fact that the building was salvageable, and the amount of works involved were not to the extreme that they are now.
Yeah. Okay. Again, one of the questions really is, as you indicated already, Mr. Goddard, we are in the position that we're in, and ministers are going to have to think about whether, whatever the rights and wrongs of the past are, whether there's a justification now or a basis in which the order should not be confirmed at this stage. I mean, this goes back to a certain extent with the fact that, and it's quite difficult in one sense, because local authorities have a number of different functions. They have a building control function, a planning function, and compulsory purchase functions, and there are kind of different parallel procedures by which these matters can be challenged. And not everything involves all of planning, building control, defective buildings, and compulsory purchase, as this one does. But there are other kind of procedures in place. And I guess one of the questions by emphasising looking at the past, I guess in my mind is, what's your argument that ought to have been done in the past that would have avoided this, and why is that relevant to the question before me in reporting to ministers as to why, given where we are now, the order shouldn't be proceeded with?
My obvious answer is why has there never been, or could still be, a retrospective insurance claim?
Yeah. I'll allow Mrs. Thompson to note that question.
Yes.
Well, I won't comment just now, because that's also a question really, I guess, for evidence of that. But that goes back, I think, to the suggestion that at this stage there is an alternative that's being made by Mr. Sibright, and the council will have a view on that.
That's correct.
No doubt the quantity surveyor can speak in his evidence on the question about the utilisation of insurance options and all of that. Okay. Yeah. Well, it still leaves you, Mr. Goddard, in the position that unless we agree a later date than next Wednesday, I think we'll be looking for preconditions from you by then for the witnesses you want to call for issues relevant to that. And also, I'd very much emphasise also, and this is important too, documents. If there's any documents they want to rely on, the council, I think, in their statement of case have given an indication, I have it in front of me here, of 5 sets of documents in different categories, from legislation to the CPO itself, planning guidance, planning policy, and relevant documents. It's going to be important too that if there's documents that your witnesses want to rely on, notice Mr. Sibright in his most recent document talks about the supporting documents section, various letters and the like. I mean, I don't think I've seen that. I might be wrong about that, but it's going to be important, I think, that all documents, even if preconditions, we may agree preconditions can be lodged a little bit later, it's important that documents are lodged by next Wednesday.
They will be.
And if documents aren't lodged on time, then when they could have been, and then the risk is it becomes very difficult then to allow those to be referred to at the inquiry.
No, I understand. Everything that he's got in that supporting document section, I have in hard copy.
Good. Okay, that's fine. As long as you have that in mind, that I need to see that and the council need to see that.
I have that in hard copy. I also have details of the Mr. Sibright's insurance.
Yeah.
Which will be included as well.
Okay. Is there anything further you want to say, Mrs. Thompson, in relation to this particular issue? Well, I'm going to come to you in a minute.
In relation to Mr. Goddard's witnesses, I will look forward to reading the terms of their recognition. I'm struggling to see what some of them might add to the process, but I'm not sure we're necessarily going to find that out right now. I still only have details of 4 witnesses. I can't quite identify who the 5th witness would be.
Yeah, I've got Mr. Gilmore and Mr. Rogers and Mr. Allison, who's a valuer, Mr. Severite himself, and I've got separately Mr. Severite's valuer, who I'm assuming is a different person from Mr. Allison.
That was perhaps my query, just so that I'm prepared for what I'm looking out for. Are Barry Allison and Mr. Severite's valuer the same people?
No.
No, okay.
That explains it.
That's
Mr.
fine.
Severite has 2 valuations.
Okay.
One by way of his expert witness for the structural report, and another one as sort of a proper, more of an in detail property valuation rather than this specific property. But I suppose you'd call it like an estate agent's valuation as opposed to a RICS valuation.
Yeah. Okay, and one of the issues we'll deal with, obviously, at the inquiry itself, is the way in which we go through the evidence. As I said, my starting point assumption is that the acquiring authority will lead their case first. With an exchange of precognitions, as the rules provide, my starting point would be that the precognitions are understood as being read by parties in advance, and I would not be expecting them to be, certainly not reading them out, because they would be available on the DPA website. And while there might be 1 or 2 points of emphasis that those leading the witnesses might want to bring out, essentially the precognition will be taken as read. And so, it may be a matter of going effectively pretty well straight into cross-examination, and that's designed to save time. So that would hopefully allow us to make reasonable progress. I'll have to make a judgment, obviously. We may have to leave this judgment to the day of the inquiry itself, whether we can finish within 1 day if we have as many witnesses as we're now talking about. But that's getting ahead of myself a little bit. I was going to go on then to what was item 2, and that's the question of the case for the council. And to a certain extent, Mrs. Thompson, you've kind of answered to a degree that issue, because you've indicated, I think rightly, that your intention is to have the enforcement officer and the quantity surveyor. You may need to have other witnesses depending what you see from what's produced within the next few working days. My questions, again, just not for answering just now, but just so you're aware of the things that are kind of beginning to formulate in my mind, one of which is an indication I've given already, and this actually ties in with the point Mr. Goddard made at the very, very start, about who's got an interest in all of this. Just to be clear about the service on the relevant people of the order, and I think it was Mr. Severite's former wife and also the Bank of Santander was issues they're raising. I've seen your certificate of 24th August 2020 in that respect, but again, just it'd be useful to get a kind of submission, if not necessarily evidence from you, about just the assurance that everybody who has an interest has had this order intimated to them, so we can answer Mr. Goddard's first point.
On that point, I was the solicitor that dealt with all of the process. Would it be better that I prepare a written submission in advance or simply address the inquiry at the time? I'm content to do either. Just given that I am also potentially questioning witnesses, it may be that is too much of a crossover, and having that prepared in advance, which I am happy to answer questions on at the time, I'm content to do either.
I mean, I don't know if Mr. Goddard has views on this. I have no strong feelings either way. But if you're willing to just issue a short statement, just confirming what you've done, so that can be on the record effectively, to indicate that all necessary intimation, because obviously intimation is important for CPO, has been given, and that no objections have been lodged and maintained by anybody other than Mr. Severite. But Mr. Goddard, do you have a view on this?
No, I'd be happy with the statement, providing it's if there are any elements that we want to challenge on it, then we can raise them at the time.
Sure, absolutely. Okay,
That's fine.
that's helpful. The other things that were in my mind, Mrs. Thompson, was one of which is just to be clear from, and maybe your quantity surveyor be able to provide this evidence, just an updated position on council funding, because I know that the funding, the early indications from the papers I've seen suggested the funding for this was available if the CPO was approved, but with time having moved on and financial years moving on, we're just into a new one. So just a kind of an update on funding, so that ministers can be confident that if approved, this is something that will be able to be implemented within the relevant timescale.
I'll make sure that is addressed by the relevant witness. From our perspective, in our statement of case, identified our senior enforcement officer and the quantity surveyor as being our principal witnesses. In the course of discussions today, I'm still not sure that the district valuer is necessarily relevant, and she's not a witness that I have spoken to about this, and I don't, if she is not relevant, I wouldn't want to potentially delay any proceedings in trying to secure her attendance for the 5th of May. However, if your view is different, I can obviously try and move things around to see if we can allow her secure her attendance if any evidence that she may give is necessary and cannot be covered by other witnesses.
I think my initial view is just not necessary as of right now. We will see what either Mr. Severine's valuer or Mr. Allison comes up with. But mindful that a district valuer would be speaking to a matter that's not within the remit of the inquiry as such, I'm inclined to leave that just now and just see what the objectors' precognitions say when lodged.
One other point, though it hasn't been raised this morning, is the query raised previously by Mr. Goddard in relation to Eildon Housing Association. Although that query hasn't come directly to us, and we did ask if it was a question they had, because I wasn't sure what information exactly was being sought for Mr. Goddard to email me, though he hasn't done thus far. Depending on the nature of, if that is a question that's going to be raised, we may have a housing officer who may who could, I need to double check that, I've contacted him, who's on annual leave this week, just because that issue has not been at the forefront of my mind as far as preparation is concerned in relation to Eildon Housing. I can speak to him and he may be a witness, but would be in a very limited terms, but it may be that he is not necessary depending on what it comes out in the precognitions. Just to bring that to your attention, there is one witness who will speak to that very specific issue in relation to the involvement of Eildon Housing Association in relation to this process.
Okay, Mr. Goddard, any comments on that?
No, that's fine.
Yeah. Okay, that's fine. My other issue that was in my mind, Mrs. Thompson, was perhaps again one of your witnesses could speak to the updated position in relation to the intended planning application. I think your statement of case indicated that this was intended to be proceeded with in the event that the order were confirmed, and I can see the sense in all of that. But I'm also conscious of the fact that the powers that are being used are planning powers to justify the order, and that relates to development and redevelopment of the land. Now, I should make clear, I recognise that the decision on planning permission is a matter for the local authority, for your council, although it could be called in by ministers under a different procedure that's not relevant to what I'm looking at. But an update on where you are with the planning position. As I say, I won't intrude on others' remit in seeking to express a view on the planning merits, but if you can give us as up to date a position as you can on the planning application, that would be useful.
Certainly. It may be that, again, our senior enforcement officer, who, although not a planning officer, does have an overall overarching responsibility for this project. That may be something he can address. But if not, when I speak to him at the beginning of next week, we can identify if there is somebody else that may be able to speak again to that very specific issue. But obviously we'll let yourself know where we stand on that, but that's something that we can make a judgment call on come Monday. There's a meeting with witnesses at the beginning of next week to finalise recognitions subsequent to this.
That's helpful. And is there anything else, Mr. Goddard, that other than those areas that I'd identified in my preliminary reading of this, that you think from the council's perspective that ought to be included in their recognitions?
Just in terms of the planning, I would like to make sure we can cover the whole planning history of the building, not necessarily from 200 years ago, but certainly from recent or past planning applications that have been made with the building.
Yeah. I mean, again, the question. I mean, obviously everything has a history, and the past is important. But again, I think it's important to consider what role I have and what purpose ministers are to put with any information, any report that I have. I mean, the justification, as I said, is under the planning legislation, and indicates the council's intentions. What alternatives they might have put the property to at some point historically, maybe of limited value in terms of the kind of overall outcomes. So sort of thinking in terms of your client's desired outcomes, it's probably quite sensible to focus on what the council's intentions are now. I mean, the past is obviously always important because it always drives to a certain extent the future. But I think in my report, I'll be probably primarily interested in the kind of plans for the future rather than the past.
Yeah, I understand. But in terms of the council's applications for the building in the past, and the works required weren't considered sort of necessary to become dangerous.
Okay. And is this at the stage before the building became dangerous, or was understood to be dangerous?
No, before the building became dangerous, there was a planning application, as I understand, for just the removal of the chimney. Then there was other applications for the change of use from the attic floors into apartments. That was all viable, and it wasn't. There were no restrictions. Now, how we've arrived at a dangerous building is something I want to pursue.
Okay. Right. Is there anything else, Mrs. Thompson, you wanted to say?
In relation to the point Mr. Goddard has just raised, I assume we are, as you've said, focusing solely on this issue rather than generally in relation to the building. Is it that this is a challenge to the planning decisions? Is this I'm querying if this is a new challenge or objection coming from Mr. Siverite in relation to the planning decisions that have been made, or is it simply to add a flavour and a colour to the overall process that this planning information is sought? Not that we wouldn't necessarily include it, I'm just concerned, is this a further objection that is coming out in the course of the discussions, in that there is an issue with the previous planning process?
Again, it comes right back to the fact that this is a multi-occupational or a multi-floor building, of which Mr. Siverite only has an interest in 1/5 of.
Yeah.
And the confirmation of the compulsory purchase order is a reflection of the entire building. So you can't really grant sort of 4/5 of a compulsory purchase order and leave his apartment sort of literally hanging.
No, indeed. I think the council would probably agree with that, which is I guess why they're proceeding with the proposal that's there. I mean,
we did have a without prejudice meeting where we discussed the fact that I actually agree. I think it's right that the building goes under council ownership.
Yeah.
But it's procedurally how it's done and how it affects different people in different ways.
Yeah, absolutely. And that, I guess, is the point. I mean, again, I don't diminish the importance of the planning history, but I think probably the main interest that I would be looking for evidence from the council to justify for the use of these particular compulsory purchase powers is about what they intend to put, what use they intend to put the building to in the future. And as I say, that's not me determining the planning application, which is not for me, but me being satisfied that the justification they have cited under Section 189 of the Town and Country Planning Act is something that has a support that would allow me to, if so minded, to recommend confirmation by ministers. I think that's that. So it's to emphasise again, it's the kind of the justification for the scheme is rooted in what the proposals are now, effectively.
Yeah. That's helped clarify certainly from my perspective as to the approach we require to take as far as witnesses are concerned. Again, I think that will be a matter our senior enforcement officer will be in a position to address, but we can clarify that when we're at the recognition or documentation stage.
Okay, right. Now I've slightly danced around the date for submission of the preconditions because I wanted to come to the end of that bit of the discussion first of all, and the date that normally would apply to 14 days in advance of the inquiry, I would apply equally to everybody. Now, obviously, to a certain extent, the various witnesses. And I've noted what you said, Mrs. Thompson. You're having a meeting on Monday with your witnesses to work out the next steps from that perspective. Each witness will prepare their own statement, and each side effectively submit them separately from the others. The starting point would be that next Wednesday be the relevant date because that gives a full 14 days notice. Obviously, if witness statements are effectively exchanged on that date, you don't know what the other side are saying. So there's no suggestion that you be mind readers and fully understand and anticipate everything the other side are saying. I'm probably still inclined to stick with that 14 days date, not least because that will give the maximum notice to allow both parties to prepare to cross-examine the other side. But I don't know if either of you, in light of discussion this morning, take a different view on that. I mean, I'll go to Mr. Goddard first. On that
I'm
issue.
happy. I could provide documents within by next Wednesday.
Yeah. And Mrs. Thompson, if you're meeting on Monday, it's a bit tight. But
it is a bit tight, but equally, I don't ordinarily work a Wednesday and Thursday, so I'm used to having to get lots of things done in the first 2. I work on Monday, Wednesday, and Friday are my usual working dates, so I've changed them for the inquiry.
Okay, so I'm realising that just now. Actually,
yes,
apologies for that. Hopefully,
no. I wanted to ensure that we were as flexible as possible to allow the matter to proceed when everyone was available. So I am quite used to having to squeeze quite a lot into the beginning of the week. As matters stand, I have been making preparations. We have outline recognitions already, documentations lined up. So it just will be a busy couple of days, but that was to be expected given the closeness to the inquiry.
I'm grateful. I'm grateful for that. Okay, now the last item I had on the agenda was headed closing submissions and site inspections. I was inclining, and probably actually I'm more inclined, having had the discussion this morning, to suggest that parties prepare closing submissions in writing within, say, 7 days of the inquiry concluding, rather than expecting either of you to be both cross-examining and writing your closing submissions at the same time. Multitasking is always admirable, but I was going to suggest you have a little bit of time to reflect after the inquiry itself before I expect people to be giving closing submissions. 7 days is the period I have in mind, but if people want a bit longer, and indeed, depending on working patterns, you may wish a bit longer. But again, go to Mr. Goddard first. Hopefully that's helpful to you, not to expect you to be making closing submissions on the day. But does that seem a reasonable way forward and a reasonable timescale?
Yes, it does. Thank you very much.
Yeah. Mrs. Thompson?
That's absolutely fine. That, from my perspective, is a full working week, because it's a Friday, Monday and Tuesday, so that gives me sufficient time to deal with it.
Okay, that's fine. And moving on to the site inspection, I'm hoping now that things are beginning to lift a little bit and I can leave my local Lord Ada, I probably could anyway for this purpose. My intention is to have an unaccompanied external examination of the building, certainly before the inquiry, possibly in the next week. But my question, and I say this largely in light of what Mr. Goddard has been saying about the state of the internal part of the building. My first point is a question. Do you think I need to see the inside of the building? And I'm conscious it's a dangerous building, so there's an issue there of safety going in, but also COVID limitations and all of that. If it's felt that there will be benefit, and I think I'm probably addressing this to Mr. Goddard mainly, if we think there's benefit in me seeing the inside of the building, we can do that remotely in some way. We might be able to find time to do that on the day of the inquiry itself. or it might be sensible to do that at an earlier or a later date, perhaps by somebody, maybe a council official who's not otherwise connected with this matter, walking around with a camera and do it by Zoom or whatever, with us attending, so Mr. Goddard can ask that person to point out things that he thinks are relevant. So there's various ways in which we can look at an internal site inspection. But I guess, in starting with Mr. Goddard, first of all, do you think I need to see the inside of the building? And if so, what's the best way to go about doing so?
I think you do. I think you should see it inside the building. But I'm assuming that there's a ground floor entrance that will allow you to just see the sky above.
Yeah.
I'm not sure that there's been the inspection scaffold has actually covered the roof, but I think you do need to see the building. Yes.
Okay. Okay. I don't know if you have any thoughts on that, Mrs. Thompson, but presumably, if that's desirable. If I was hoping we might be able to do that on the day of the inquiry. It is sounding as if there might be a little bit more evidence that's required on the day than I might have anticipated initially. I'm not sure what the best way to deal with that would be. I mean, it may well be that we return to this issue on the day of the inquiry itself, and then fix a later date. We in DPA have become relatively experienced now in having virtual site inspections. Often, and this won't quite work here. Often how it's done is the appellant holds the camera effectively, and we agree in advance the viewpoints or locations or things that I should see, and then the appellant or his agent would walk about with the camera and point these things out. No evidence is intended to be led at a site inspection, but that's one way of dealing with it. It might be that actually it should be a council official that walks around the building under Mr. Goddard's direction, and points the camera at the things that he wants me to see. And equally, Mrs. Thompson, you have a say in that as well. But it might well be that, I mean, what we could do is arrange that for the day at, say, 2 o'clock and have an official travel to Jedburgh to do that and be ready. Or it may well be we just try and do that maybe on the Friday, whatever, when you're next working. And do that on a separate day. I'm conscious May the 6th election day as well.
May the 6th is absolutely not a day that I am able to. It's possibly the busiest day in a local authority.
It's not a great time, is it, from that point? I know counting starts a little bit later for this particular day, but we could do it the next week might be better. Or we could do it in advance.
And from my perspective, I'm not involved in the election because the count is over a weekend, which I'm not able to. It's over, which I'm not able to facilitate. Also, I do not live in the borders, so that from a site visit perspective, we have recently I am the legal advisor to our local review body, and we have had a pre-recorded visit where both sides have submitted any points that they want to be included, and one of the relevant planning officer, as was the case in relation to this, did a walkthrough. The walkthrough side of things is what we would need to be. There would need to be a risk assessment and how best to facilitate that. But whether that worked, certainly we did it through Teams, and after a few teething issues, because although I do not live in the borders, obviously all of our councillors do, and we do have some rural internet issues to try and stream videos and such like. That was, and again, it's an information gathering rather than anything, that was quite successful for a site visit in relation to, I think it was heights of buildings or something. So we have because of we've had to make those changes ourselves in relation to our planning and local review bodies where a site visit has been considered essential. So that is something else that we may be able to. My issue of a live action may be strugglesome given necessity for reasonable internet connections and the potential difficulties that may present. Equally, is it something that could be dealt with by a visual external view and internal photographs being taken with, again, guidance from what Mr. Goddard would like to be shown? That's something that could all as just another alternative.
Yeah.
Again, I'm just conscious of potential internet difficulties. If Mr. Goddard is struggling to see people today, if we were to add a live video or even a pre-recorded video into that, I appreciate that can cause.
That could be difficult.
We have experienced some rural Wi-Fi issues with our councillors on that basis as well. So just those were two. I've no difficulty with a view being taken inside. It's just how best and how safe to facilitate that.
And I suppose my one question, before I come back to Mr. Goddard to respond to that, my one question, I guess, is whether anybody feels that I need to have that before the inquiry, in other words, to make sense of the evidence, or whether I can hear the evidence and then at a later date find an alternative way, as I say, not straddling too much the election period, or whether it would be sufficient that we could kind of park this issue right now and then come back to that once the other evidence is led. But Mr. Goddard.
I'd rather you saw the building before the inquiry. I think it's important to understand sort of what we're trying to discuss, and particularly when it comes to sort of issues over scaffolding, we can see sort of what parts are dangerous, or in your opinion, what parts have been overprotected or underprotected.
Yeah. And do you have any thoughts on Mrs. Thompson's suggestion of photographs or?
I don't know. I don't have any burning desire to sit sort of live. I think any sort of historical video walkthrough is sufficient, with possibly sort of stills from internal shots as well. That's fine.
Okay. Right, what I'll do is I will reflect on that and do what we've done with the assistance of Graham Mason, who's facilitated this particular call. He tends to be a bit of our expert on these things, and then in the period between now and the 5th of May, find some way without diverting either you two more than necessary from your preparation for the inquiry, to be finding a way in which we could do that, and identify the kind of the things, the bits that would be useful to see either by video or by photograph. So if you leave that with me, I'll pursue that. Okay, right. That are the agenda items I had. I don't have anything else I want to specifically raise for just now. I think this is recording of this will be available either this afternoon or beginning of next week. But I don't know if anybody else had any other AOB at this stage they wanted to raise.
No, I'm fine. I have the dates in order and can make sure I can achieve those dates. That's fine.
Right. Okay. I see Mrs. Thompson was.
Yeah, absolutely fine.
That's fine. Okay, well, many thanks for your constructive contribution towards discussions this morning. That will hopefully, once the preconditions and documents are lodged, make things as effective and as efficient as we can in proceeding with the public inquiry on the 5th of May. And we'll, I'm going to see you all there soon. Hopefully I can see Mr. Goddard soon, but we'll be together for that on the 5th of May. So thank you very much. I'll close the meeting. Thank you.
Thank you very much.
Thank you.